Board Assistant Clerk of your first district is now in session. All those with cause, please all rise. Their attention and shall be heard. May God save the United States, the great state of Florida, in this honorable.
Please be seated. Okay, let me warn the attorneys. It looks to me like we probably have some students in here today, so perform well. Give them a good show. We have two cases on the docket this afternoon. We're going to take them in the order that they appear. First one is Sermon versus State. Are both sides ready?
Yes, Your Honor.
Appellant may proceed.
May it please the Court, my name is Todd Savage. I represent the appellant, Brynn Sermon. I'd like to reserve 5 minutes for rebuttal.
Okay, I'll try to remind you, but you'll have the clock in front of you.
Thank you. The issue in this appeal is very much straightforward. In the underlying trial, the defendant raised the affirmative defense of consent to entering into the dwelling of the alleged victim, Ms. Keenan, in this case. The defense raised this affirmative defense by presenting, in fact, the testimony of the alleged victim, Ms. Keenan herself. Ms. Keenan was
the trial court required to believe her testimony, especially when she had been impeached?
Your Honor, the testimony presented, the sole competent testimony presented in this case on the issue of consent was by Ms. Keenan, although she was attempted to be impeached with inconsistent statements.
I'm sorry. Let's do two things at a time. I know you're saying that the sole competent testimony of, consent is hers, and let's get off that issue for a second. Was the trial court required to believe her testimony, especially since she was impeached?
Your Honor, our position would be that the trial court was bound to accept the testimony of Ms. Keenan in this case because there was also no other testimony to the contrary in this case. Okay,
well, let me explore that with you a little bit. We have a domestic violence injunction here.
That's correct.
While I understand that can't be the sole evidence of non-consent, isn't that circumstantial evidence that the trial court can consider?
I don't believe so in this case, Your Honor. As we pointed out in our brief in this case, while there was a domestic violence injunction in place, the testimony of Ms. Keenan, in our opinion, certainly overrides that domestic violence injunction. She alone had the ability to testify in court as to what her state of mind was or whether or not he was or was not permitted to enter her dwelling that day. It is undisputed that the domestic violence injunction was still in place. However, that is not tantamount or exceed or
let me explore a little bit further with you. Couldn't the trial court take in consideration the testimony of at least one witness that at the time of the second entry into the house, he was pulling her by the hair, and when he got her inside, he hit her and choked her? Couldn't the court consider that being non-consent, considering the fact, if you believe this woman's testimony, that she was trying to get away from him where he'd been hitting her outside?
If I understand your question, you're referring to one witness saying that there was a scuffle and then the victim is brought back inside. Again, Ms. Keenan herself testified that in fact was not the case in this matter. And
I understand, but wasn't she impeached with her prior statement given to the police that she in fact had been pulled inside? That she was hit?
You're talking about the victim here?
Yeah, I'm talking about the victim.
The victim, the state attorney questioned her concerning her prior statements. Of course, those weren't in a trial or deposition or other hearing. She acknowledged that those statements were previously written, but she continued to disavow throughout the trial and never changed her story that the defendant in this case had permission to enter the dwelling.
Well, it goes back to my initial question then. Is the trial court bound by the testimony she gave at trial?
We believe that that's the case, Your Honor, yes. Your Honor, going forward with this, again, as we've mentioned, Ms. Keenan in this case unequivocally testified that the defendant had a key to her apartment. She was aware that he had a key to the apartment. She testified at the trial that he had permission to be there. That permission was, in fact, not revoked at any time in this case. Now, after she presented that testimony in this case,
her testimony was that she lent him the keys to the car, and he took that opportunity to copy a key to the dwelling.
Correct, and she was aware that he had a key to the dwelling. That was her testimony.
Did that occur after the domestic violence injunction was in place?
I do not know the answer to that. From our transcript, I'm not sure if we have that from the transcript or not in this case.
Let me explore a policy issue with you. You know, it appears in a lot of these domestic violence cases, women rescind their testimony. Is it good public policy for us to say that we're bound by the victim's testimony given at trial? I mean, there's a serious public policy implication here.
Well, I think to address that public policy issue, I think particularly I can say in this case, I think that yes, we would be bound to it. I mean, I try to liken it to a different situation. Let's say this was a domestic violence injunction. The typical injunction says that you can't, contact, touch, or whatever, or come within the person's dwelling or residence. In this case, if it had been a circumstance that a law enforcement officer had seen the defendant and Ms. Keenan walking hand in hand or sitting in a park or kissing in a park somewhere, and that law enforcement officer was aware of the domestic violence injunction, if he were to arrest the defendant in that case, would he charge the defendant with battery? If the victim were to come in later on and said, no, he had my permission to touch me or to be near me, I think it's the same sort of issue in this case. Here,
in that case, you have only testimony of one outsider who was saying that there was not a problem going on between the two. Here, you have testimony from at least one other outsider and the officers when they arrived on the scene that all wasn't peachy keen at the time.
Well, I think as a public policy matter, to answer your question, yes. In this case, the only person, the sole person who could testify as to whether or not he had permission to be there is the victim in this case. The other witnesses who were there, of course, law enforcement, of course, wasn't there at the time of the incident. The other witnesses, Ms. Bryant and Ms. Pledge, had no testimony concerning whether there was consent or permission. As we mentioned in our briefs, unequivocally, the evidence established that there was an assault in this case. The evidence established that there was a battery. There was evidence established there was a violation of a domestic injunction, all three of those issues being misdemeanors. The evidence supported those charges in this case. However, the evidence in this case is not legally sufficient to establish a battery in this case. And, we, of course, cited into our brief to this court two cases from the 4th DCA.
You mean is not sufficient to establish the burglary?
Correct. Yes, sir. Correct. If I misspoke, I apologize. Then this, of course, we've cited.
Instead of battery, let's explore that a little bit. Would there be, looking at the burglary, was there sufficient evidence to find out that he had the intent to commit a battery upon her when he entered the apartment the second time?
I don't think that is the case. Here there was the evidence. One witness testified that she witnessed a slap or a hit outside of the residence. Another one testified that she saw a slap inside the residence or hit inside the residence, but not outside. In this case,
also had his hands around her neck.
Inside of the residence, correct. One of the residents testified to that event, and she also was quick to notify to limit that by saying that he was not choking her, but had his hands around her.
Okay, but taking all that evidence, was there sufficient evidence to find that he had an intent to commit a battery when he entered the residence the second time?
Your Honor, the issue that was, I'm not sure how to answer that. Quite frankly, the evidence in this case, I think we've gone over what the various witnesses said. Whether that would be supported an intent to commit a crime in the inside, I don't know. The evidence in this case was that the defendant was already in the dwelling when Ms. Keenan arrived. There was testimony from various witnesses that the defendant and Ms. Keenan had been in verbal dialogue prior to this actual incident. One of them said that on the phone, another one said they had been arguing earlier in the day. When the victim arrives at the house, the defendant is already in the home, comes outside. As I stated before, there was clearly an incident, a physical altercation outside of the residence when they first got there, and there's testimony that there was additional physical interaction between the two once they were inside of the residence. And again, one of the our salient point on this, and when we're citing the two DCA cases from the two cases from the 4th DCA, is that in those cases, which we feel the facts were certainly more egregious than we have in this case, in both of those cases you had multiple witnesses testifying that the defendant in fact did not have permission to be in the residence in that case.
In one of those cases, Didn't the defendant also have a possessory interest in the house?
That was concerning, I think, on the domestic violence injunction side. On the two cases that we have concerning the issue of, that's the Mentalis case and the Hansman case. In the first case, the Mentalis case, the factual allegations were that the defendant was running from law enforcement, ran through an apartment, and came out the other side. In that case, the sole owner of the apartment testified that the defendant hadn't been there in over 4 weeks, that she didn't give him any permission to be there. The law enforcement officer who was in pursuit himself testified that he never saw the defendant speak to anyone to gain permission. In that case, the defendant raised, in his own testimony, self-serving testimony, stated that the fiancée of the apartment owner had given him permission in that case. Well, the 4th ECA in that case determined this was not sufficient for the state to meet their burden of rebutting the affirmative defense beyond a reasonable doubt. Likewise, in the Hansman case, you again had 3 owners of an apartment. Facts in that case indicated that the defendant allegedly had broken into the apartment surreptitiously, had broken through a door, had removed property and items. The state in that case called 2 witnesses, 2 of the 3 apartment owners, both of which testified that the defendant, in fact, did not have permission to be in the residence. Again, the defendant himself, on his own accord.
4.5 minutes.
Yes. Thank you. Your Honor, at this point, we would just suggest again that, of course, the 2 cases cited that we've cited in Talis and the Hansman case, we think are certainly supportive of our position that if reasonable doubt wasn't established, or if the state didn't disprove the affirmative defense beyond a reasonable doubt in those cases, they certainly didn't want to hear. Thank you.
Good afternoon, Your Honors. Please, Court, I'm Charlie McCoy here on behalf of the state. Your Honors, the state's case in chief, if you all consider it in its entirety, and I will be back to that in a second, if you consider its entirety of itself rebuts consent for the defendant to have re-entered the apartment after the altercation began. Now, almost intuitive, I think the first reaction is why would somebody, if you believe the eyewitnesses, who at very least was slapped and hit outdoors and fell to the ground or was even dragged across the ground, ever consent to the assailant following her immediately back into the house? It makes no sense at all. The state adduced evidence from 2 eyewitnesses, that was her co-workers at the daycare. Even the version that was elicited on the stand would have supported lack of consent. Now, the first of the 2 co-workers, a woman named Rakoya, testified on direct exam that the defendant pulled the victim on the grass toward the parking lot, punched her twice in the parking lot, and the victim ran to the house and slipped. Now, first off, nobody's going to consent to have somebody follow him back into the house after being punched. But the fact that she ran away from him implies that she wanted to get away from him, reasonably and presumably to shut the door before he could get back in, not wanting him to follow her in. That's from the state's case in chief as elicited on the stand. The second victim was, the second co-worker, Your Honor, was more equivocal. I think she probably deferred to her friend, the victim's desire to get the guy in some trouble, but not as much trouble as is obvious he was in.
Yeah, he's in very serious trouble, right? He's been sentenced to life in prison
Yes, Your
because
Honor.
of these events.
These events, and I think his prior record, if I recall, was a prison release reoffender. I do want to...
How old is Mr. Sermon?
I don't remember, Your Honor. The victim was 20. I don't think he was much older than she was, but I just don't remember beyond that.
And he's in prison for life because he was convicted of burglary with intent to commit assault or battery.
Yes, Your Honor.
And the victim, the person whose house it was, said that she did not object to his coming in the house.
When she was called as a defense witness, Your Honor.
And you're saying that the trial judge did the right thing because there was evidence that from which the jury could conclude that, beyond a reasonable doubt, that in fact she did not consent at the time, even though that was her testimony at trial.
Right. You have essentially 2 conflicting stories, at which point it should have gone to the jury. I don't think this is as hard a case as, with all due respect, the other side has made it. The fact that they raised consent or as an affirmative defense really doesn't change your basic premise of the judge's role in evaluating motions for judgment of acquittal. Sort of answering the question you posed, Judge, well, if you don't...
Well, now, I noticed that there was discussion about you make out a prima facie case, and then consent has been held to be an affirmative defense.
Yes, Your Honor.
Was there any case where you could grant a motion for judgment of acquittal if these were the charges?
I didn't find, no, there's not a case where, I'm not sure I understand your question, Your Honor.
All right. They raised an affirmative defense of consent.
Yes, Your Honor.
You don't get to that question until you have a prima facie case that the state makes out.
Yes, Your Honor.
So...
I'll begin to find.
So is it the state's position that the trial court can never grant a motion for judgment of acquittal when the defense to burglary charges is consent to entry?
The only circumstance I think that could arise is where probably inadvertently or unexpectedly a witness flips on the stand and changes their testimony after being called by the state, so the state's case in chief actually has evidence of consent, sort of the same way that if a state's case in chief allows a reasonable hypothesis of innocence and the defense counsel moves for judgment, in a circumstance case, moved for judgment acquittal on that hypothesis. That did not happen here. I mean, the first witness, of course, said that the victim ran to the house and slipped. That's how he caught up to her. You don't run away from somebody if you want them to follow you in the house. Even the second, more equivocal co-worker, well, no, she said the altercation occurred inside the house. It was all verbal outdoors. But the victim herself, on direct, as part of the defense, agreed that he slapped and hit her outside, chased her around the car. But I want to make two quick points. Without objection, when the state was eliciting testimony from the two co-workers, the prosecutor alluded to their written statements. There was no objection to that. I'm not aware of any pretrial ruling agreement in limine that was used only for impeachment purposes. I think the court would have been entitled, the trial court would have been entitled to listen to the substance of what the prosecutor said was in the written statements as part of cross-examining those co-workers. And the written statements obviously are far more damaging, but essentially the written statements made the attack more vicious outdoors.
Wait, now, you're saying that written statements that were not introduced into evidence?
Well, the substance was used as the basis for of the state's direct exam.
Wait a second, though. When evidence comes in as impeachment, can it form the substantive basis of the charge?
Well, there's not.
You'd have to show me some law that says that.
Well, let me answer you this way, Your Honor. There wasn't a pretrial ruling that they could come in only for impeachment.
If it only comes in for impeachment, can it be substantive evidence of an element of crime?
For purposes of assessing a motion for judgment of acquittal, I think it can under this reasoning, Your Honor. This court has held, and it's been held other places too, that even improperly admitted evidence can be part of the mix in determining the legal sufficient state's case.
It's not improperly admitted evidence. It came in for one limited purpose, impeachment. I believe there are a number of cases out there that say impeachment evidence cannot be used as a substantive basis for a charge.
Well, there wasn't any ruling to that effect in the record.
But wait a second. Forget the ruling and the effect. What did this evidence come in for? Was the statements, when they were referred to, were only done on cross-examination to impeach the trial testimony. Isn't that correct?
But
they were not introduced during the state's case as substantive evidence, were they?
The state used them, alluded to the substance of the written statements in its direct exam of the two co-workers. There wasn't an objection, there wasn't a request for limiting instruction to the jury that that was only for impeachment, but it was before the court. There would be, if the state had impeached its own witnesses, then there's no evidence of anything, perhaps. But I think the stronger point, and one I do want to emphasize, is that the evidence that she ran back to the house, she slipped, that's when he caught up to her. That of itself is enough to say she did not want him re-entering the house after the assault had begun. Now, I do want to address a point here. Judge Wolf, you asked if the domestic violence injunctions would be evidence of non-consent. Well, certainly the fact that she obtained them, the fact that they were still in effect, certainly means that at least generally she didn't want him around. She had perhaps victim's remorse and was allowing him back in the house. I do want to point to the language of temporary injunction. This is from the standard form when it's an injunction, minor children involved. And the record does include testimony by an officer that he was served with the temporary injunction. And the standard language is any violations of injunction, whether or not at the invitation of petitioner, may subject respondent to civil or indirect criminal contempt proceedings. He was certainly aware, at least constructively aware, that those injunctions were binding on him. But I still want to go back to the primary point that when someone flees after an assault has started and goes back to their house and he caught up with her when she slipped, there's no way that that's enough evidence from which a jury could reasonably infer that any consent he had up to that point to go back in the house had been revoked by the victim. And besides, nobody in their right mind who had started to be attacked outdoors. They went from a telephone argument earlier in the day to what sounded like a little more confrontational verbal argument when the victim arrived home to, depending on which account you believe, being slapped or hit and dragged across the grass outdoors. She runs back to her house. Seems to be undisputed that he put her hands around his neck as if you're going to choke her, which I think is an aggravated assault. So, Judge Benton, I think there was legally sufficient evidence there, not just of a battery, but of an aggravated assault, maybe two batteries, one outdoors and one indoors. So I think that if you look at the state's case in chief and the fact that she left under the circumstances that she did and tried to get back to her house before he could catch up to her is enough. I think, Judge Wolf, maybe it was you, maybe Judge Brown, you asked if the court was required to believe the victim. Well, the court's not required to believe anyone in assessing the motion for judgment of acquittal based on the case in chief sufficiency of the case in chief sufficiency in light of the affirmative defense of consent. You take the evidence at face value. Is it, now, I'm competent and substantial. The case law says any evidence, well, competent substantial evidence is implied. If we could do this case over with the benefit of hindsight, I wish Judge Decker, who did a very good job here, had said, instead of saying the victim was effectively impeached, had said, given this, this, and this, that she went to the state attorney's office for the weapon assault portion, the charge to be dropped, that she had her most recent child by this defendant and so forth. I wish she'd have said that as a matter of law, that's not competent and substantial evidence. If y'all are willing to read her remark that he was effectively impeached as tantamount to saying the victim's testimony was not competent and substantial, then you don't have any legally sufficient evidence of the defense of consent, so the state wouldn't be required to rebut anything. If y'all are willing to read Judge Decker's remark that way, then consent was never sufficiently raised and the state wasn't required to rebut it. But I do want to close by going back to the strongest point, and that is no one who's just been, depending on whose account you believe, punched, slapped, knocked to the ground, dragged across the grass outdoors is going to consent to the assailant following her immediately back into the house, no matter what happened up until that time. She moved away from him rapidly enough to either slip or she was running. Her own written statement said she ran, and there would be no reason to do that if she wanted him to follow her back into the house. And from that, reasonable jurors could conclude there was not consent. So at that point, you have two different sides of the same story. That is consent and non-consent. It was required to go to the jury. Judgment of acquittal was probably denied, and we'd ask that y'all would affirm that ruling. Thank you.
Just want to hit a few salient points. There was a suggestion a moment ago that this court could perhaps read Judge Decker's comments to suggest that perhaps the consent defense was not even in fact established in this case. I think that would be certainly contrary to the jury instructions that were provided to the jury in this case, wherein, of course, that it's mentioned that the state has to prove beyond a reasonable doubt that the defendant did not have the permission or license to enter the dwelling. It's my understanding of Florida case law that that is not an element the state has to establish in their case in chief, but in fact is in fact an affirmative defense in this case.
Don't you agree that Mr. McCoy has a point that the events as they were recounted by the witnesses suggest that she did not want him to come inside.
I do not, for the reason that Ms. Keenan herself did not testify to that event, to that extent.
What if Mrs. Keenan hadn't testified at all?
If Ms. Keenan had not testified at all in this case, I mean, we might very well have a different outcome on multiple levels. But of course, she did in fact call. She was not called by the state in their case in chief. I believe the reason for that is she had previously testified in a previous hearing in this case that's in the record. That again, in the previous bond hearing, of course, she had also testified there was no permission. I mean, that he had permission to be in the dwelling. The state did not call Ms. Keenan, ostensibly because they knew she was going to say he had consent to be here. And in fact, then it was incumbent upon defense to, in fact, raise that issue and to call her as a witness in their case. Ms. Keenan, as we've discussed.
So you're in a situation where you adduce direct evidence, her testimony, that she did not object, that she did consent to the appellants coming into the house.
That's correct.
And on the other side, all the evidence is circumstantial.
Her evidence was, I think we're talking about whether or not the defendant had the permission to enter this dwelling. The dwelling, in addition to the defendant, was solely occupied by Ms. Keenan. It is her testimony and her testimony alone which is salient on the issue of whether he had the permission to be in the residence on the day and the time that this incident was in question. The fact that there was, as we previously admitted, there was assault, there was a battery. Every time there is an additional crime, and it occurs partly in a home and partly out of a home and back into a home, doesn't bootstrap that particular crime into a burglary in this manner. So, you know.
I'm having a tough time, though, in these particular circumstances where somebody's being battered and run away, that you can't say that the only reasonable interpretation is that they would not want that person to follow them back in the home. I mean, I guess my question is, do we throw common sense out the window?
Your Honor, I don't think that we have to throw common sense out the window. Again, I mean, I think this situation can occur in multiple levels. You take it into a husband and wife context. You have a husband and wife that are, both have permission to be in a home. There's a fight that begins in a home that goes outside the home, comes back inside. Fight re-escalates inside. You have something inside and outside. There's a starting point at any point, and then the fact that an issue might culminate inside of a home, whoever's being battered is never going to want the person in their residence at that time.
The only difference is there is one case that talks about two people having a possessory interest in the home. Here, this person had no possessory interest in this apartment.
That is correct. He doesn't have a possessory interest, but he does have the invitation and license to be there, according to the sole person who could testify to that, Ms. Keenan. Your Honor, I guess we'd ask the court, of course, in this case, to reverse. We believe that Judge Decker erred in denying the defense motion for judgment of acquittal on the burglary charge. Again, he was convicted of the other charges in this case. However, because he's ultimately convicted of this burglary charge, despite the victim testifying he had the permission to be there, he is serving a day-for-day life sentence as a PBL, and he was a PRO on that. Thank you.
Thank you.